Present.
Mr. Tatum, Mr. Tatum, Ms. Williamson, Ms. Williamson. All right, Madam Chair, 3 of the 5 members are present. A quorum is present.
All right, perfect. So before we get too far, just wanted to let everybody know that the meeting minutes from the May 16th meeting have been posted to the task force website. So if anybody has noted any corrections, please let us know now. All right, hearing none, then the meeting minutes are approved. So as everybody knows, last time, I think we pretty much wrapped up with the permanency conversation, and now we're moving on to the preponderance of the evidence discussion. And Will did do some work and has prepared some statistics based on the 3rd data set. So I thought it'd be helpful to have him start with that so that we all have that same information.
Thank you, Madam Chair. I'm going to share my screen here, and just I suppose as a way of apology to the members, this is a little bit of a rough presentation because I'm just working from spreadsheets here, since those are working documents and just easier to work with generally. But I just wanted to draw your attention to 2 spreadsheets based on the 3rd DHS data set. This first one is for table 3 from data set 3, which breaks down the evidentiary standards upon which disqualifications were based by race. And this is essentially reiterating what you heard on Friday. Well, those of you who were at the Friday meeting, that Mr. Cameron reported from the data analysis meeting. But essentially, the data analysis group has been looking at these statistics in particular and highlighting with the usage of preponderance of the evidence, how we can see significant racial disparities compared to Minnesota's population as a whole by race. So for example, that 40% of preponderance of the evidence-based disqualifications in 2018 were in the of people in the African American category versus 49% in the white category, which is quite disproportionate to Minnesota's population as a whole. And how we can see a pattern like this, in particular with the more serious, as it were, disqualifications. So for example, with permanent bars, 63% of those based on the preponderance of the evidence standard in 2018 were of African American applicants versus 26% white applicants. And we see this trend across both years. Here's 2019, 50% versus 34% African American and white in those years. And then looking at the permanent bars, 65% and 27%. So I can answer any questions or keep this or bring this spreadsheet up if you're interested in discussing it further. But it is sort of reiterating some of what we went over on Friday. The other thing I wanted to point out was data sets, table 6 from data set 3. Table 6 breaks down the crimes or conduct that led to a disqualification by the evidentiary standard used to make that disqualification determination. And what I've done in this spreadsheet is essentially calculate what percentage of each crime, each disqualification for a crime was based on what evidentiary standard, which that's clear as mud. But so for example, 100% of violation of predatory offender registration law disqualifications in 2018 were based on a conviction. 65% of 4th degree criminal sexual conduct were, that sort of thing. I made that calculation and then I ranked the crimes, disqualifying crimes by those based on a preponderance of the evidence standard. So for example, 0% of assault in the first degree based disqualifications in 2018 were based on a POE standard. And about 13.5% of assault in the 2nd degree disqualifications were. And so, if you do this sort of ranking, I'll just walk through, if you're interested, I can walk through all of these tabs with the disqualification standards, but just to highlight what I'm seeing here. The most prominent disqualifications based on the preponderance of the evidence standard were in the 7-year category, most particularly for domestic assault. which comports from what I think we've been told by members of the department before, that domestic assault in particular is something they try to apply this standard for. And we can see that in 2018 and 2019. In 2018, 41.5% of disqualifications for domestic assault were based on POE. I started out in 2018 with permanent bars, so we can see that some permanent disqualifications, and therefore bars for second degree assault, were based on POE in 2018. We can see a very small proportion of theft disqualifications in 2018, 15-year disqualifications based on POE. And then jumping to 2019, the main thing I'd point out is we see a notable change over time between those 2 years. So again, this is 2018. I have highlighted in red essentially a percentage large enough to register in this calculation. In 2019, as you can see, there's a significantly higher number of disqualifying crimes that I've highlighted in red here, and higher percentages as well. So now we're up to about 30% second degree of disqualifications for second degree assault, permanent disqualifications based on a POE standard. Again, jumping to 2018, that's 13%. So it's more than doubled. And likewise, we see about a quarter of some CSC disqualifications, bars based on POE. And down the line, this is aggravated robbery. It's only 5% of disqualifications based on that, but these are permanent disqualifications. And to a lesser extent, I see this trend in the 15-year disqualifications for 2019. Again, there's a lot more red here than in 2018. And while some of these are relatively low percentages, about 1% for 1.5% for theft, for example, we're up to 15.5% for third degree assault. So I don't really know why we see these changes, but this just seems like the main thing that jumps out to me that I'd like to highlight to you. So thank you.
Thank you. And Will, I know it's a working document. Could you email that to all of us so that we can?
Absolutely, Madam Chair. In fact, I believe you should have a copy in your inboxes right now.
Okay, perfect.
Yep.
And maybe you had already sent it.
Yeah, it's the email with the subject line agenda, which confusingly enough has more than the agenda attached.
Got it. Okay, perfect. So, I see it here. Thank you. Okay, so I think that definitely kind of starts us off. And I feel like, I don't know how other members feel, but the preponderance of the evidence seems to be a topic that we kind of keep sort of bubbling up as we've been talking about permanency. And I think we've probably talked quite a bit about it. So I'm trying to decide with our group members that are here today. I think we all understand it, or I think we do. If there's any, maybe start off if there's any sort of questions to begin with about it, or if we want to sort of launch right into some discussions.
I think Chair Dawson, do you see that? Still can't stumble out of my mouth. Well, I think another document that would be really good for us to look at, is all the states document, because I was just taking a peek at it, and like, we are super rare in how we do this. And I think having everybody look at how really rare we are is going to be really important. And so, yeah, I have that document, or if you want to pull it up, well, I think that one's pretty startling and how strict we are.
Yeah. Oh, there we go. Perfect.
Ms. Evans, Madam Chair. So yeah, just as a caveat, these essentially were my background notes when I was doing all that research in January. I'm I'm returning to this and I'm firming all this up, but just take all this with a grain of salt. Especially, I'd highlight because when I cite statutes here, they're not necessarily apples to oranges with 245C. These tend to be the child foster or child care statutes in the states in question, and they might, for example, have a separate statute governing other areas that 245C would govern, like people working in nursing homes or the like. But with that caveat, the language you tend to see in other state statutes is a conviction as a basis for disqualification.
Couldn't we assume though, if their child care and foster rules were conviction, that they wouldn't be more stringent for adults?
That was my tacit assumption, Ms. Evans. Yeah, that's why I use that. Well, one of the two reasons I use that research strategy.
I mean, and I turned my camera off because I'm working from home today and have a little bit of internet connectivity issues, but I could see policymakers in a state having different standards for the two. I mean, does anyone think that maybe we should try to, I know it's a ton of work, but try to figure out if in the, like the healthcare fields, the states are also, I mean, I think we're going to find that I think your assumption, Will, is right. But I just wonder, like, if this is an issue that we're likely to get pushback from in the main group or even going forward at the legislature, like sort of dotting our I's and crossing our T's on that might be good. Mm-hmm. That going through some of that stuff, we're just getting a new batch of summer law student interns at Legal Rights Center. So that might be something that I could help you with, Will.
Okay, that would be a great conversation to have offline, Mr. Esme. Okay. And yeah, I keep highlighting the limitations that I see here with my work here, just exactly because of that. I'm not comfortable just relying on that assumption and would like to fill out this work further, which I'm starting to do.
Yeah, and Josh, if you have access to law clerks, that's great. I know in my office, we're actually short on law clerks because we have people studying for the bar. So our summer, while they're full time, we're short. So
yeah, we have 4 new 2Ls starting tomorrow. So,
and it would be great to have a attorney doing it that understands like law and statute and
agreed.
We're just kind of jumping into this and going where the conversation takes us.
Yep.
Right.
That's kind of my thought. I mean, I just, especially because I feel like the preponderance of the evidence, I feel like we have already talked quite a bit about it. I think it's great to just go wherever we go.
Well, I think we, towards the end of last session, did like a little kind of straw poll, and it seemed like all of our official members, at least who were present last session for this subcommittee, were in favor of eliminating the preponderance of the evidence standard altogether and going to a conviction model. So with that assumption going forward, I think, go ahead.
Well, that's not true.
Oh, it isn't? Okay.
Kelly Moeller was not. Because of.
Is she on this subcommittee?
Oh, yeah. Got it. No. Yep. You're right.
So, yeah. So I'm thinking that that's likely to be our subcommittee's recommendation and what we should then spend. So given that I don't think we need to spend a lot of time coming to a consensus on what our recommendation is, I think we should use the time that we have blocked on this issue to really sort of firm up how we're going to present it to the group.
Yeah.
One of the things I think that would be really important to do to that end is to consider what the best counter arguments are. So maybe if Kelly is one of the people that we think is going to be arguing against it, like maybe we want to actually hear from her.
Mm-hmm.
I think it'd be great to invite her to hear, because there is a part of me that is curious what's her basis. I genuinely want to hear it.
Yep. And I talked to her about it and she said she's not the best person to talk about it because she doesn't really deal with a lot of the child protection cases and a lot of because when they need it is for child protection cases and domestic assault cases where someone had a good lawyer and like they know that the thing actually happened. They just can't prove it. And
Right.
so,
And I think obviously
and she just said she's not the right person to do
Yeah.
it. And Max pretty much alluded to the same kind of thing. And so what she was saying is like, there would be somebody better to come talk about why they need this. And then one of the things she was saying is that maybe going from a preponderance of evidence standard to a clear and convincing standard would be something that opponents would be willing to look at. But there is a case for this where
well, and of course that's where I'd be interested in the conversation, because as somebody who actually practices in the clear and convincing realm, nobody really knows what it means. Nobody can actually define it. Our case law is less than clear. It's not, and so that's, to me, that leaves way too much discretion to whose definition of clear and convincing versus, to me, also, is the compromise instead, what about the cases where there is that admission, where you've got maybe the stay of adjudication or an Alford plea, where you've still got that plea, you've got the acknowledgement, because I struggle with the whole somebody got a good lawyer. Well, everybody should be entitled to a good lawyer. And maybe that's why the statistics are so awful, because it's, somebody who has the means can actually get a lawyer to prove the case.
Yeah, on those statistics, one of the things that I thought was interesting that I think we could think about and maybe use in how we frame the issue is not only was the disparity for African Americans disqualified by a preponderance of the evidence really high compared to the general population. If I was reading it right, and correct me if I'm wrong on this, Will, but
really low.
That across the board, it was like 40% disqualified for preponderance of the evidence, but it was lower than that for convictions, lower than that for Alford pleas, lower than that. So I'm really wondering what sort of conclusion we can draw from that. Is this like a junk in situation where people of color are more likely to be charged with poor cases that don't end up with convictions, but still end up showing up on DHS's radar for a POE determination? Or is there something within, and this is why I asked at the big meeting if we could get sort of the flip side data on disparities in POE declined cases to see if there is actually something affecting that data going on within DHS's discretion. And maybe we're not going to be able to piece that out, but I think there's potentially a really strong argument that the use of preponderance of evidence is one of the things that's driving the disparities.
Yeah, well, and one thing that I just thought of is, because sort of, and obviously Representative Moeller is not here to defend herself, but the whole about domestics where they just sort of know, I kind of think some sort of education on actually our domestic, first of all, statutes, because our statutes are actually broken down into two pieces. There's actual harm and there's fear of harm. And I think, and I will tell you also, as somebody who used to practice divorce law, domestics go directly to custody considerations. And so I can't tell you the number of times where it becomes, oh, we're getting divorced. Hey, let's start bringing up a whole bunch of domestic allegations from previous. So there can be a motivation tool. They're some of the easiest to charge because it's a he said, she said. It can be done by simply citation. The other thing is, I think even based on some of that, I'd be curious to actually bring in some prosecutors, because some jurisdictions, like Dakota, for example, if you have no prior criminal history and you're charged with a domestic, you are offered diversion. You're offered essentially a continuance for dismissal because they don't want it on your record. That is literally what the prosecutors will tell you. And so I think this whole, and I know I'm getting a little on the soapbox about domestics. I think I've just seen them from so many different sides, and I've represented victims, I've represented perpetrators, that there are for sure the genuine ones, and then there's some of the others.
Yeah. So another thing where there's disparity by geography, depending on where you live, has a huge impact on how that lands on your record.
And that's for sure too, because like Dakota offers diversion. Some of the Hennepin County cities will, some of them will not. Carver refuses to do continuances for dismissal. That's just their policy, apparently. So you're not even getting the same treatment depending on where you are.
County to county.
County to county.
Yeah.
If I could just build on that real quick.
Yeah.
I had a trial setting literally just today on a domestic, and it was not even like a romantic couple. It was two sisters in their 30s who were like temporarily living together, that had an argument that ended up having the cops call. They both basically said that there was some pushing and shoving, but no injuries, nothing major. Both, well, my advocacy, but also the alleged victim, the sister's advocacy, she basically begged the prosecutors for 6 months not to go forward with the prosecution, said nothing happened. It was a misunderstanding. She didn't want to go to trial. She gave a statement saying that the pushing and shoving was mutual anyway. And the prosecutor went forward with the case, even though he knew he wasn't going to have a cooperative witness, brought a motion to proceed with just the 911 call, which there's case law on that is actually like really permissive to allow prosecutors to prosecute domestic assaults just with the 911 call. And we were pushing the entire time for that continuance for dismissal. Also, my client had all of these equities. Like, she had done so much work, like self-improvement work, since then. And so the prosecutor wasn't even asking for like any programming. There was no anger management. There was no Rule 25. She'd already done everything that you'd ever ask her to do. And it was just kind of keep doing what you're doing. And even though, as Chair Dawson pointed out, some cities have just a blanket policy on a first-time domestic that they'll do a diversion or a continuance for dismissal. This prosecutor was like, absolutely under no circumstances, we will never do a continuance for dismissal. And she ended up pleading guilty. It was to a disorderly conduct with a stay of adjudication, which is a decent deal, sort of, in the abstract, but like not really given the actual facts of this case that was charged. And it's just a really good example of, I think, the kind of behavior that A, is not really that big of a deal in the first instance, but B, whatever harm was caused was already completely repaired and healed by people, that still nonetheless ends up going forward with these prosecutions. And my client does work in healthcare, and so now we're in this position where, because of the preponderance of the evidence standard, we're doing the best we can to prepare for the sort of unknowable possibility of whether DHS will come in at some point and take her job away, and and then trigger us going through this entire process for something that both sisters say was a misunderstanding in the first instance. And so I just put a point on it. The existence of the preponderance of the evidence standards creates a ton of havoc for practitioners on the criminal side, because you can't predict what's going to happen with DHS. It's really hard to work around. I'm trying to advise my client on, how much worse is a stay of adjudication with an admission to a disorderly conduct versus if we could have gotten that CWAP versus if we went to trial and won. And the answer is no. Who knows? because it's all going to depend on what the attorney in the licensing division, how they decide to weigh, the outcome in the criminal case versus what they read in the police reports.
Right.
So,
Well,
it
and
makes it
I
really
will
difficult.
even say, I've definitely seen where it can be a husband and wife. It can be 100% mutual, but it's only the husband who gets it because sometimes there's still, this bias
Yeah.
that, so not,
I would even call it stigma.
yeah, that it must be the husband. And, and I think even to Josh's line, I've had one parent-child roommates where there's no romantic relationship. It's just simply roommates, but because they live together, it's charged. So domestics is one, especially that I think, and especially just with us, again, they can literally be charged by citation. That the amount that comes back from them, and especially when kind of the criminal justice system, the acknowledgement is to try to get the services and understand that dynamic so that it doesn't happen, but yet we're then disqualifying people and taking away their livelihood. Especially when it's not required. I think I'm 100% in favor of protection for victims. I think I'm not in any way saying that, having represented several where definitely had lots of concerns for their safety, all of that. But not every case is that. And that's sort of, and I just don't think our statutes can be, I think the problem with tailoring our statutes to those cases, we end up bringing in more people than the statutes are really meant to protect or to protect against.
Every case is worst case scenario. That's how we treat it. Every
Right.
case is worst case scenario instead of it's the 10% that we need to be concerned about. And how do we write our report to speak to that?
Well, and I think
we
that's
have
where
a paragraph at the beginning that talks about that,
yeah,
that the net is catching too many people. And that here are the cases that we're talking about. And here, how do we talk about how many of them are the ones that are the bad, like, how do we, yep.
well, and I wonder if that's where the net is catching too many people. The repeats, those are clearly didn't learn. All right, if we want to talk about keeping the repeats in, to me, I can get behind that much more than I can your first time. So many might have no prior criminal history, none.
Well, the other thing is, actually, Lucas, can I jump in?
Yeah, of course.
Yeah. I didn't want to cut you off if you weren't done with your thought.
No, I was just, going after it all.
But I just want to bring it back to exactly what we're talking about right here, though, is the preponderance of the evidence standard. Right. So the only cases we're really talking about are people who got charged with a domestic, and that case did not end up with a conviction, which either means it didn't have facts that could sustain proof beyond a reasonable doubt, or much more likely in my experience, I'm sure there's some subset of these preponderance of the evidence cases that were trial acquittals, but and maybe this is something we can dig out of the data, I'm not sure, but I would be willing to bet that the vast majority of them are plea bargained to disorderly conducts or the continuance for dismissals if they're lucky enough to get a prosecutor who's in my humble opinion, has a little bit more perspective and sees how it works more clearly. Mm-hmm. And so those folks, kind of to Gina's point, like these are the folks that are the furthest away from repeat offenders. And there's already been discretion made by prosecutors about how to handle these cases where the prosecutors made a decision that we didn't need to pursue that domestic, which they won't do if they think that they have a truly abusive person.
Right. Well, and I think to sort of second guess and say, we know there are cases where somebody essentially got away with it, then we're not also trusting the prosecutor. Like, we need to also trust the prosecutor who makes that agreement, who sees the cases, who's reviewed the evidence, who's talked to the detective, who's probably talked to the victim. In some respects, we also just have to trust them to do their job. They're there to represent the state. So this whole sort of backdoor big brother isn't necessary. Like, that, I don't see the need for it. And I just think that then that's overstepping by, I think, other groups.
And I wonder how often that is catching first-time offenders. And could we get that data from DHS? Like, how often are these preponderance of evidence? Like, how often is that somebody, it's their right? And would that data be impactful to the opposition to say, here are these 200 cases or whatever, and this is how many times that was the person's first domestic case or whatever? Because I feel like that would be important, like thinking about who I'm going to have to argue this with at the Capitol to say, we think that this giant net is helping us keep the community safe, but here's how many times that preponderance of evidence in domestic cases, it's actually that person's first thing.
Hi, Dawn. Nice to see you.
Do you think that would be? Hey, Dawn.
I wanted to add.
Go ahead.
Well, I just wonder if that would be something that
I wanted to add.
Yeah.
Oh, sorry. Go ahead, Dawn.
No, like you make perfect sense though, Gina. Like I had a situation like that. Like I had the police called on me at my brother's house and they tried to give me a domestic. I just didn't go for it. I'm like, I ain't did nothing to nobody. I called the police. Why am I, I don't beat nobody up, and this is a bad situation. I'm having a horrible time right now. She shouldn't be at my brother's house, and she had called the police on me and tried to get me arrested for a domestic, and I was with somebody else, and it was just a bad situation. They just tried to throw me in a tangle, and I'm like, no, I'm not going for that. No, I'm not pleading to nothing. I didn't get nothing. I didn't get no domestic or nothing, but they tried to just trap me in that little situation though. And, I went to court and they dropped everything. And I'm like, nah, I'm not going for that. It was my oldest daughter. My oldest daughter, mom, we had a situation we were going through, childish. I called the police, she called the police. She didn't want me to be with somebody else, and we were never together. It was just a bad situation that she just wasn't okay with. And I almost got caught up in some, a situation that could have had something on my record for a domestic that probably could have bothered me down the line. There's something that I didn't do. My brother out of town, I'm watching his house. She shouldn't be at my brother's house. But that could have been turned around a totally different situation. Like you said, preponderance of the evidence. Was he hostile? Why was he acting this way? What do you mean? Why am I not acting this way? I'm watching someone's home while they're on vacation. And somebody shouldn't be in his home. And you're telling me I gotta leave? That doesn't make sense. It don't make sense. It's my brother.
And what if you wouldn't have known enough to fight it, right? And just like lay down like lots of folks do, right?
Yep.
Right.
Could have got me. They could have trapped me with that.
Yeah, and I think especially the domestics, they come with, because even a misdemeanor domestic, especially if there's harm or allegations of harm, you lose your gun rights. I mean, so there's other collaterals that come with that. Gina, the other thing, just I really want to circle back to, because you had said, I think at least your understanding of the concerns from Representative Moeller was not only domestics, but also some child abuse. So I'd be curious specifically what it is, is it like the malicious punishments specifically, or is it something more child protection related? So that just, again, another kind of curiosity piece.
Yep. So I wonder, I'll just say this quick, and then Josh, if you want to uh, share your thing. I wonder if having one of the folks from foster care or whatever bring somebody in if we wanted to hear more about that. But those were the two areas that she was concerned about, because those are the two areas that they use it the most. So that's all.
Josh, what were you going to say? We can't hear you.
I was gonna say, I was wondering about that too, because I wonder if what is going on there is they're looking more at the serious and recurring maltreatment findings that the county does, as opposed to working with criminal cases. And because if it's the latter, I don't think we're thinking about, I'm sorry, if it's the former, if it's the serious and recurring maltreatment findings, I don't think we're talking about making a recommendation on that provision at all right now, correct?
No, I don't think so. Well, and at least with the serious and recurring maltreatment, somebody at least has the right to due process and the right to challenge it and have a hearing on it. So there's a part of, and again, to get to that serious and recurring, you've got a little bit worse of a situation. I mean, you're talking about a more serious situation, and you have due process where you can have a hearing on it. So,
but are we talking about getting rid of POE altogether, right?
I think that's been our conversations about our group's recommendation. I still leave open, and I'm wondering what the group's thought are on where, because obviously preponderance of the evidence is there's no admission versus if there's been an admission, a stay, whether you've got a stay of adjudication or an Alfred plea. I don't think we've necessarily touched on that as much, but I guess I lump it in a little bit more with the POE because it's not your standard conviction, which, as we've seen, a lot of states require convictions. So a stay of adjudication would not be part of it. I guess what are groups' thoughts? To me, that could potentially be the compromise. And especially where you've got somebody who's made the admission. But I'm open to what other people think.
I mean, one thing that jumps out to me on that is that sometimes these collateral consequence statutes actually have a very broad definition of conviction that would include stay of adjudication anyway. So I'm not sure that it's fair to assume that just because Kentucky uses the word conviction, that means that they wouldn't disqualify on something like a stay of adjudication. I know in like immigration courts, for example, when we're looking at immigration consequences, they have a really broad definition of conviction. There's some particular, like when I've looked at like some of the military enrollment criteria will consider a stay of adjudication to be the same as a conviction. So just to flag that's another place where it's I think Will said clear as mud before. But in terms of Chair Dawson, your sort of suggestion that might be sort of a good middle ground, I think that would be fine with me. I do think part of me doesn't really like the way that sort of cuts the legs out of a disposition that is an important one in the criminal legal system, and one that is an acknowledgement that all of the parties are trying to reach a compromise explicitly designed to limit collateral consequences. So I kind of don't like the idea that the statute would be written in a way to remove the ability for the parties in the court to achieve that goal. To me, it actually does seem like it would be better if the criminal process had that say, because I think pretty much invariably the parties in the criminal case are going to know and have a better sense of what the situation really is than someone from DHS who is looking at it maybe even years down the road. So I kind of don't like that. If you've got a judge accepting a plea agreement that the prosecutor agreed to that was designed to limit collateral consequences, and to have all of those parties' intent frustrated by a statute that, you know, lets somebody who's further from the facts make a decision about it later on. I kind of don't love that. At the same time, though, I think it is a point of compromise that, like, strategically might make sense.
Well, and I think just sort of to piggyback on that, especially like a stay of adjudication where someone can then qualify for an expungement, even if, for example, it's a permanent disqualifier. So kind of, I don't know that I would want to, I mean, that is still at least an option that's out there for people to potentially still recognize the benefit of the plea.
Yeah, that's true.
But yeah, so I guess, I mean, we have enough to, I guess, do people want to, maybe what makes sense, I don't know that we want to, I think most of us seem to pretty much be on the same page, but I wonder if it would make sense for the next meeting, if it's possible to get somebody who's kind of this counter to come in and talk to us before we vote. I think it'd be good for us if we're at the point of voting on our final recommendation, that we've had that other perspective. I think voting before that would be premature. How do people feel about that? And I don't know who would be a good person. What are people's thoughts? Would it be Max? Would it be somebody from completely outside the committee?
So I feel like Max would be a good person to ask who a good person would be.
Okay.
And so, because Kelly wasn't sure who from, because she works on appeals or something, like she's not in that work exactly.
Okay.
And so I feel like Max would be a good person to ask who a good person would be to talk about it.
Okay.
So, and maybe it's him, or maybe it's somebody from the County Attorneys Association, or
Do we have any victims groups on the large group task force?
Nope. And I've talked to Nikki several times from the Minnesota victim, Nikki Engel. Where is she from, Josh?
I don't know her.
I don't know her.
And they're ready to come in and do a large presentation or whatever we, Violence Free Minnesota. But this would not be, this would not be what they would come in and talk on, I don't think.
Right. And I think, because one thing that's curious for me is, I mean, we're talking about disqualifications from working. We're not talking about, you know, modifying the actual domestic statute or modifying the court process.
Yep. And this is a specific subject we want them to talk about. We want them to talk about when they are using POE in this, however number of people that they're talking. It's not a super ton even. Like, what are the cases that they're using it in? And like, what are we missing? Because in our mind, looking at other states, looking at how few it is, like, or how many it is, and the cases you all are seeing, like, in our mind, let's get rid of it.
Right.
It looks like conviction's the way to go. Tell us what we're missing. That's what we're looking for, somebody to come in and do so that we can make a decision. And like asking Max who that would be.
Yeah, I think that would be, yeah, if we could ask Max. And then Gina, you had brought up a really good point about if it's possible to understand from DHS, specifically, I think along the domestic assault POEs, how often they're the first time offenders. If there is, well, I don't know. Can you reach out? How do we do that?
Yep.
Who do we ask?
Madam Chair,
Are we,
ultimately, yeah, I could reach out to DHS and make that request. I would suggest that we rope Ms. Williamson in as chair of the data subcommittee, just
Yep.
essentially to, it's her subcommittee that handles those sort of things.
okay,
Yep.
and maybe it's, yeah, no, that makes sense. So if we could, if maybe it's just an email offline, roping her in and then getting that request out. And then also maybe an email. I don't know, maybe I have Max's email. I might have Max's email that I could shoot him an email and copy you, Will.
I have another data thing.
Sure.
While we're thinking about it. So how to frame this? So one of the things, since I'm talking, I'm going to try to turn my video on, but if I just I might have to turn it off again. So one of the things that's on our agenda to talk about further on in the summer is what the appeals process up to the administrative law judges ends up looking like. And one of the things that is potentially really nice and really clean about eliminating the preponderance of the evidence standard altogether is that it would actually, I think, really limit the amount of cases that need to go up to an ALJ, because you can still go to an administrative law judge to appeal, DHS's discretion in denying a set aside, but that's a much narrower issue. And the main reason, at least what I've seen in my practice, why you'd end up getting to administrative law judge is when you're challenging whether DHS was correct in making its preponderance of the evidence determination.
Mhm.
And when you do that, you end up basically having a miniature trial in front of an administrative law judge where the parties present witnesses and evidence, and you can raise defenses like self-defense, but one of the things that I think that we could sort of use in our effort to sort of sell the idea of getting rid of the preponderance of the evidence standard is that appeals process is not nearly as, how should I say that? It's very, very hard to actually win on that appeals process because there's no rules of evidence. So, any hearsay can come in. The police report itself is enough for the administrative law judge to make a finding that there's preponderance of the evidence. Preponderance of the evidence itself is so low. It's basically 50.1%, right? My friend and colleague, Emily Baxter, used to call it a whisper over a coin flip about whether or not this thing happened, right? I litigated one 5-6 years ago now at this point it was a higher level case. It was it was a first degree assault, but it had taken place in another state in the 70s. My client was the victim of abuse. Her abusive boyfriend ended up going to prison like 6 months later and did like 15 years in prison. Everyone in the community knew. And she was defending herself when he was confronting her after she was trying to leave him. But she ended up getting arrested, charged with first degree assault. That charge was dismissed. The only thing she was ever actually I'm sure she was arrested on first degree assault. So that's where the POE came, was from the basis for the arrest. But the prosecutor didn't charge her with that. They only charged her with carrying a firearm without a license. And even that was dismissed because just everybody knew that she was the victim here. And then she moved up to here to Minnesota, became a foster mom, did fostering with no problem for like 15 years until like suddenly a background check came up and DHS permanently disqualified her. And we had the hearing. I tracked down the guy, her abusive boyfriend. He testified via phone and told the judge that he was threatening her and that she was just defending herself. But the prosecutor was dead, so we couldn't have anybody tell the judge why. There was nobody from the police department connected to the case that knew anything about it, but they still had the police reports, and the police reports still had these statements from witness bystanders who said that they saw her acting angry and erratic. And the administrative law judge found those statements from these untested witnesses from the 70s to be more credible than the testimony of my client and the abuser, and upheld the preponderance of the evidence determination.
Would you be willing to I don't know, give that presentation, I think, sort of to the large group as we're coming in with our recommendations? Because I think that speaks not only to the concern about, hey, there may be these cases where we know it actually happened, but just how much can come in. We're talking about something from the 70s.
Yeah,
I just feel like that's a
I can try to
case
track her
study.
down. I don't know. It's been a while. I can't promise I could get her. I definitely could, I could present on it. But I'd also, and the reason I started with the data is I'd love to see, does anybody win these preponderance of the evidence challenges? Like, I wouldn't be surprised to find out that it's like, 10% of the cases that go to an ALJ have a finding against DHS. So if that's something that we could find out, that would be great. And then I think there's a way that we could sort of frame it as just not needing to engage in this really problematic and unfair, process if we just eliminate the preponderance of the evidence stuff altogether.
No, I think that's good. And so, yeah, Will, did you write that? You got the note on what we're looking for? Okay. Maybe so when we email to Shonda, we can loop her in. Dewan, I see your hand.
Yeah, I just wanted to add in, like what he was speaking of, like the people coming in. I got the 2 guys for Chair Geffen too, that the EJJ guys.
Okay.
I got them ready. So whenever we have the large group too, so I probably should send an email out just to let them know and give them the names. And
That's definitely good to know. And I think the subcommittee chairs meet separately. So we have a meeting next Wednesday. Gina, I'll make a note, but if you're gonna be there, also make a note to just bring that up to Chair Geffen.
Yep, I can make a note and tell me what exactly.
Or will you make a note too,
Yeah.
to bring up to Chair Geffen that Dewan has some speakers from the EJJ? Are they actual people who have gone through, are they lived experience, or is it
made it through the program,
got it?
older now, and how it affected them over time, so.
No, that'd be great.
When we sat down and talked about it, you're friends of mine, so we grew up together, so.
Perfect. Yeah, well, I think 3 of us are all on that meeting and have tried to make a note. So hopefully one of us will remember to remind Chair Geffen next Wednesday during the meeting.
It's next Wednesday. I just had to make sure if they asking me whether I had them prepared and stuff. So
yeah, well, and they wouldn't have to be ready by Wednesday, and I don't know for our schedule.
Madam Chair, the next task force meeting will be June 24th. You weren't there actually, but we changed the schedule a little bit.
Okay, yep. So our next one is June 24th. So I don't, obviously if they are needed by that one, they'll have some notice.
Okay, yeah, it's not a big deal. Like this is a rush or something we can, change up or whatever, whenever. I just want to hear the story again. Like with Jamel, it's an amazing story. Like, man, go from 15-year-old to standing on you didn't get to play in the Jets game, but you're standing on the sideline in uniform. You get it, go from nothing. It's just an amazing story, man. It's super motivating. Yep.
So I think unless anybody else has anything else for today, homework for kind of whoever's got homework. Will, if you could put together an email looping to Shonda in with those few data requests and just copy me. Josh, if you wouldn't mind seeing just if you can reach out to that former client, and obviously nothing urgent, but just if I'm assigning stuff. I will send an email to Max and loop Will in about potentially coming to speak at our next one. So that we've got that. And Josh, I'm not necessarily planning that you would do something with our subcommittee. It'd be more once our subcommittee is ready to present to the large task force. So I will see if Max could be, or if he can tell us somebody who's a good idea for our next meeting, which is June 20th. So I will work on that and try to have something ready to go for that. And then I think if we can get that data back on the first time offense, get somebody in, I think we're pretty close to kind of finalizing our recommendations for the POE to then ultimately, probably sometime in July, go to the large group. Sound good?
Yeah, and then I'll just add one more piece of homework for me is I'll connect one of my interns with Will to make a plan to find the rest of that other state comparison data.
Perfect. Thank you. I'm glad you remembered that. Perfect. I think we've all got our homework. And if there's nothing else, last chance. Perfect. I see a thumbs up. So we are good, and we'll see everybody on June 20th. Well, in our small, yeah, I suppose, because we'll be before the next large groups. Okay, perfect. The meeting is adjourned. Thanks,
Hi,
everybody.
everyone.
Everybody,
Have a good week.
bye, Duan.